Three Kenyans, Issa Elanyi Chamao, Patrick Karani Ekirapa, and Paul Ngweyo Kirui, have filed an urgent application in court to halt the ongoing bipartisan talks between Azimio and Kenya Kwanza, facilitated by the National Dialogue Committee. The applicants are questioning the legality and constitutionality of the committee's formation, arguing that it violates several provisions of the Constitution.
Parliament, as it is, can be able to decide on the issues without forming this kind of committee.
Through their lawyer, Peter Wanyama, the petitioners cite lack of a legal framework to guide the collection of views from members of the public, arguing that a 7-day timeline was too short for the collection of views on pertinent issues that have a bearing on the amendment of the Constitution.
We do not have a law, for example, that says this is how you undertake public participation. All that the Supreme Court has said is that before major decisions are made, you need to consult to the people, you listen to them, you hear what are their concerns, so that the final product that is made, if it is going to be a report, an administrative or any other action, it would have been informed by the views that you got from the people.
The petitioners further faulted the National Dialogue Committee for outlining issues for possible constitutional amendment without a legal framework to guide the process of amending the Constitution.
The 5 issues identified by the Dialogue Committee suggests that there is going to be a high possibility that the Constitution would be amended. Then a legal framework would be necessary. This is by passing a law that would govern that process.
The petitioners also argued that the issues identified by the committee are politically driven, citing the omission of important stakeholders such as the Law Society of Kenya and civil society in the composition of the committee, which they accuse of pushing for constitutional reforms to satisfy their personal political interests, sentiments that have increasingly been echoed by a section of politicians.
The outcome of this dialogue committee will be disastrous for this country because the Azimio will hijack the outcome for their own political gains and not using it to benefit the Kenyans.
If you are going to have new counties, you are going to require a referendum. The number of issues that you can do without a referendum are very few.
Also listed in the petition is the use of significant public funds for a process that they say is not supported by the Constitution. According to the petitioners, the public will lose at least 100 million shillings in paying for expenses of the committee and its members. In their prayers, the petitioners want the court to certify the application as urgent and the court to issue conservatory orders stopping the National Dialogue Committee from considering issues for the amendment of the Constitution until Parliament enacts legislation to guide consideration of constitutional questions that are before the National Dialogue Committee.
This legal order has an expiry date. And this expiry date is by April 2024. The Constitution requires that all the constituency and wards should have been reviewed.
Through their lawyer, Peter Wanyama, the petitioners want the matter referred to the Chief Justice for the empanelment of a 3-judge bench. Michelle Ngele Odhiambo, K24.